Disclaimer: this is not legal advice. Legal advice can only come from a licensed attorney in the state of Texas. It is only an overview to acquaint you with the structure of this document. ETX Realty Solutions Express LLC is a business to make a profit buying and selling real estate. And ETX Realty Solutions Express LLC does not provide real estate advice to buyers or sellers. The first part we run into is the parties. This just describes who is buying the property and who is selling the property. The second part describes the property. This needs to be the legal name of the property that can be found in the tax assessor's website. You can go there to get it, or it may be on documents you already have. Then, continuing with the property, basically anything that's attached to the house or anchored to the property is included in the sale. Note that a TV is not part of the house, but the brackets on the wall are. The final part, dealing with the property, if there is anything that's attached to the house or anchored to the property that the seller wants to keep, it must be added in Part D and agreed to by both the buyer and the seller. The sales price. The sales price is the price that will be executed in this contract. It's divided into two parts. There is the cash part, and then there is the part that's associated with a loan. It can be a third-party loan, loan assumption, could be seller financing. The sum of the two will be the total price paid for the property. The license holder. This would be if someone was a licensed real estate agent involved in this transaction, they would have to declare it at this point. We, however, would like to declare that ETX Realty Solutions is not licensed by Trec. However, we disclose that we are involved in this transaction to create a profit and do not provide real estate advice to the other party. Earnest money. Whenever a transaction takes place, it's customary to place some money with a third party in order to consummate the contract. This is where that information would go. The title policy and survey. That if someone is buying a property, they want to be assured that when they get the property, they actually own it. The title policy gives them that assurance. This identifies who's paying for it. Is it the buyer or the seller, and who is going to issue that policy? Usually the title company. Continuing on, there's a need for a survey in just about every real estate transaction. There's one of three ways a survey can take place. The survey can either be an existing survey that is just used again. It can be that the seller gets a survey made, or the buyer can get the survey made. Commitment. Within 20 days after the title company receives a copy of this contract, the seller is obligated to provide the commitment and exception documents to the buyer. And if the documents are not delivered within 21 to 36 days, the contract may be terminated by the buyer. The survey. We already mentioned that it can be created or it can be used from a previous time. Survey. This is where you would check off which one of the three sources would be the survey for this contract. Objections. Sometimes the survey will expose exceptions or encumbrances that were not known to the buyer at the time of the offer. This situation can terminate the contract up to the specified number of days after discovery. Title notices. It is advised that the buyer have an attorney examine the title during the time limited on the buyer's right to objection. If the property is in a POA or an HOA and this membership is mandatory, it must be disclosed to the buyer. Statutory tax districts. In some areas there is a requirement to use specific utilities, and it is provided more or less as a tax district. If the buyer is obligated to take over payments, then the seller is required to bring all accounts up to date and disclose to the buyer that they will need to take over payments. Tidewaters does not apply in East Texas. Annexation. If you're buying a property that is outside of a city limits and it looks like the city is going to be swallowing up the area through annexation, It is required to be disclosed to the buyer that that will be happening in the near future, if it is known to the seller. Utility service provider. Again, there may be mandatory water and sewer providers in this area, and that must be disclosed to the buyer. Public improvement districts. Okay, there are some areas where a municipality requires payments because of improvements that are being made in the area. If this is the case, the seller must inform the buyer of that obligation. Transfer fees. If there is a private transfer fee involved, the seller must inform the buyer of this obligation. Propane or water level fluctuations. If this property is in an area serviced by propane, the seller must inform the buyer. If the area is on a lake and the lake level has large fluctuations throughout the course of the seasons, that must be also informed to the buyer. The seller disclosure. Any of the items on the previous screens need to be disclosed in a timely manner. Select one of three boxes. Either the seller has provided notice to the buyer, the seller will provide notice to the buyer within a specified number of days, or the seller is not required to furnish notice. But one of these three boxes has to be checked. Lead-based paint. If the house is older than a 1978 build, there is probably lead-based paint. This needs to be informed to the buyer. Acceptance of condition. The buyer may purchase a property in an as-is condition and the seller will not be obligated to repair anything. Bank financing may override this section of a contract. The buyer may require the seller to repair specific things prior to the sale. Check the box and identify. Lender required repairs. In the process of underwriting a loan, the banks may find things that they object to, and if the contract is going to go through and financing is going to be available, the seller is obligated to make the repairs or the contract may be terminated. Completion of repairs. Any identified repairs must be repaired by professionals. No handyman is allowed to be involved in this. They must be licensed and preferably insured. Permits must be pulled for all repairs. Environmental matters. Environmental matters include asbestos, endangered species, wetlands, and any situation which may make living in the house dangerous or restricted, and it must be disclosed. Residential service. Residential service contracts are typically a cost reduction instrument used to give the buyer some peace of mind when purchasing the property. It is often offered as a warranty, but it is not as comprehensive as most buyers think that it should be. Brokerage fees. If a real estate agent or brokerage is used in this transaction, then fees need to be handled. Closing. The buyer needs to specify when the closing will take place. If the seller agrees, then the contract will be exercised on that date. At the closing. At the closing, the seller shall deliver the title in exchange for the offer price. The title company will assure that the title is clear. If the property has tenants, the lease and deposit money will be transferred. Number 10, the possession. If the buyer needs to take possession prior to closing or the seller needs to stay beyond closing, a temporary residential lease shall be used to accommodate these needs. Leases. After the effective date, the seller must get consent from the buyer for any change in the lease on a property. Special provisions. If the buyer and seller have agreed to any special provisions, it needs to be disclosed on the purchase contract. Settlement and other expenses. If the seller has any liens on the property, they must pay it by closing. If the bank restricts the buyer from paying certain fees, then the seller must absorb them. Buyer expenses. Buyers shall pay loan application fees, origination charges, credit reports, recording fees, insurance fees, etc. Prorations. The seller has obligation to pay their taxes and maintenance fees for the portion of the year that they own the property. The buyer is to start fresh upon purchase. 14. Casualty loss. Once the contract is in effect, the property must be maintained in the condition the buyer made their offer on. This means that if there is a fire or a break-in, that the property shall be brought back to the effective date state as soon as possible. Default. Upon the closing date, if the buyer cannot execute the contract, the buyer shall forfeit the earnest money and both parties shall be released from the contract. Mediation. The state of Texas encourages mediation when there is a dispute rather than going to court. 17. Attorney's fees. If a dispute occurs and attorney fees are a result of that, the prevailing party is entitled to have their legal costs paid by the other party. 18. The escrow. Typically, a title company will be holding the escrow money. The holder will not be liable for lost interest or lost money due to non-performance by the buyer. Expenses. Earnest money will be applied to the down payment and expenses at the time of the closing. Demand. Escrow money will be released if both parties agree. If not, then if one demands the release of the escrow, the other party will be notified. The other party has 15 days to release or dispute. Representations. If the house is sold as is, the representations survive the closing. This means if something is discovered that was not disclosed, the discovery may be actionable by the buyer. Federal tax. Everyone is obligated to satisfy any federal tax associated with the sale of the property. Notices. All communications must be in writing and both parties need to know how to contact each other. This is the section for putting that contact information. 22. Agreement of the parties. The contract can be expanded with addendums, and a checkbox identifies which addendums will apply. Termination option. Option money is paid to the buyer. It provides a period of time agreed to by the buyer and seller to allow detailed inspection of the property. If within that option period the buyer decides to back out, they back out, losing the option money but reacquiring their earnest money. The option money may be applied to the down payment, but it is non-refundable, and the check boxes in the section identify if that is the case. We have section 24, which is the signing section. Consult an attorney before signing if you're unclear about anything. Final signing of the contract is at this location. The option fee. Built into this contract is the receipt for the option money that was described earlier. Also, there is a receipt for the earnest money and the contract money, and this is the official receipt for that. In conclusion, the Trec contract is comprehensive and designed to address every aspect of the transaction. The contract is legally binding. Be sure you understand what you are signing before you sign it.